disturb me. I have it when I open. Thank you. Thank you very much, Ms. Adeti, our CEO, for helping us through this function. My gratitude goes to my colleagues on the Radical New Bar Governing Council, Mr. Vice President and Mr. Treasurer, for your service today, as well as our colleagues who are online, council members for Eastern, Western, and Northern Uganda, who could join us on short notice because they'll be joining us for important council business in the new week, over the weekend as well, actually. I would like, in a special way, to give gratitude to our secretariat team, led by Ms. Christine Awori. Yes. Thank you. Ms. Christine Awori, after this, please come. Ms. Christine Awori, our CEO, and our rule of law team led by Ms. Afra Apio, please come up for recognition. Please join me here. Mr. Gaudius Tuyasingura. Gaudius Tuyasingura. Yes. And Ms. Patience Gwen. She around. Yes. We would like to, from the Radical New Bar Governing Council, would like to appreciate you for your service. Much of the acclaim and flowers goes to us, but really you are the engine behind our service on behalf of the Uganda Law Society and the people that you work with. Yes, today is not the day to speak about our legal aid team, but I'm sure the presence of the CEO is sufficient recognition that we appreciate. Yes. My Lord Mayor, Your Worship, this is our rule of law team. As you see them, your petition is in good hands. You've done a great thing to recognize your corridor in Sibuku, to come back home. Charity begins at home, and we love it when our members recognize that the battle needs to be instructed in a formal way by members who seek its services in terms of Section 3C of the Uganda Law Society Act, our duty to protect, represent, and assist members of the legal profession as regards conditions of practice or otherwise. This is properly within our remit. Thank you for working here with great humility and divine purpose to hand over this matter to this 69-year-old institution. These JNCs are in charge now. You can go and see. Mr. Vice President and the Treasurer, our member and distinguished Lord Mayor for Kampala Capital City Authority, greetings. This is to present our statement on the General Court Martial in light of this petition you have presented this morning, which, as you correctly stated, was brought to our attention earlier on in some form by the lead counsel, Honorable Martha Karua, who we had the chance to meet as part of our consultation process at some point during your proceedings. It's sad that we can't have her here to present it herself, but you have done it justice. She covered almost similar ground when we met her, shortly before bedtime, one of those days you were in court at her residence. So we have received another petition from the International Bar Association, the Human Rights Institute. And we have received similar calls from the Regional Bar Association, the East Africa Law Society, and concerns. I am in communication almost daily with the President and Vice President of the Society of Kenya to ensure the safety of their colleagues who are performing in Uganda. Behind Honorable Martha Karua, I understand there's a team of jurists, not only from Kenya, but across the world. And the proceedings at the General Court Martial have been of great concern for the International Commission of Jurists, which is housed in Kenya, the Kenya chapter. So this is not the only petition the society has received, and we are open to receive more petitions, and we assure the public that we will give these petitions treatment, the rightful treatment they deserve. Colleagues, on some day which is still being discussed, someday soon, possibly this month, I believe next week, I will lead a delegation, a high-level delegation of the Uganda Law Society to meet the Chief Justice of Uganda, Honorable Alphonse Chigamoy Owinidolo, this time on behalf of countless individuals and families whose lives have been torn apart by the lack of clarity on the legal framework governing military courts. This matter has plagued our justice system for nearly 2 decades, resulting in egregious, the worst form of violations of fundamental constitutional rights, and it demands immediate redress. The time for action is now. The Uganda People's Defense Forces Act, almost now well known as the UPDF Act, which commenced on the 2nd of September 2005, included Section 119, subsection 1, clauses G and H, which have been the subject of endless and chaotic interpretation by the judiciary of Uganda. This is what the UPDF Act provides in the aforementioned section. 119. Persons subject to military law. The following persons shall be subject to military law. G. Every person not otherwise subject to military law who aids, or abates a person subject to military law in the commission of a service offense. Now, a person ordinarily subject to military law is a serving military officer. So this section 1G says that every person other than a serving military officer who aids or abets a serving military officer in the commission of a service offense will also be subject to military law, or what my senior colleague has called martial law. And H, every person found in unlawful possession of, item number 1, arms, ammunition, or equipment ordinarily being the monopoly of the defense forces. And item number 2, any person found in unlawful possession of other classified stores as prescribed. That, in essence, is section 119, subsection 1, clause G and clause H. Now, 42 justices in the Court of Appeal and Constitutional Court of Uganda, as well as the Supreme Court of Uganda, have spent a total of 25 years examining whether this section is inconsistent with Articles 28 Sub-Article 1, 126 Sub-Article 1, and 210 of the Constitution. In simple terms, 42 justices of the Court of Appeal, also sitting as the Constitutional Court of Uganda, and the Supreme Court of Uganda, the top court of Uganda, have taken 25 years of legal time examining one question: whether the trial of civilians in military courts is unconstitutional. Think about that. 25 years is the median age here at the Uganda society. So you saw Gwen before she was born. The judges were examining this issue. Now she's giving me advice as a member of the Rule of Law Department. And the judges are still examining this question. There is an interesting book for those of you who love literature by Charles Dickens. It's called Bleak House. Anybody who knows it and you get 100,000 shillings? Bleak House. It has an interesting opener. The case of jaundice versus jaundice. Judges have come and gone. Lawyers have come and gone. But the case of jaundice versus jaundice remains at preliminary stage. It was supposed to be about a simple issue. Who should benefit from this estate? Generations of the original beneficiaries have since passed on. But the record records adjournment after adjournment. No witness has ever been heard. You must understand now, if 200 years have passed, which witness is there to be heard on the original question of the will of the jaundice estate? I think this is where we are. The initial challenge, constitutional petition 18 of 2005. 2005. So this act was passed in September, 2nd September 2005. Do you know who moved first to challenge this particular provision? It was the Uganda Law Society. In September of that year, the Uganda Law Society challenged Section 119, subsection 1G and H of the UPDF Act. In CP number 18 of 2005 versus the Attorney General, in favor of upholding the constitutionality of prosecuting civilians in military courts. In Constitutional Appeal number 1 of 2006, the Uganda Law Society had filed a cross appeal. So which means that the Uganda Law Society challenged the UPDF Act extensively. It challenged so many provisions, not just this one. And it won on all those provisions except this one. So the government appealed on all the other provisions, and the Uganda Society filed a cross appeal on this particular issue and another issue, which again is important for you, trying civilians jointly with a serving officer. So I'm here to tell you, colleagues, that we are sorry. Our ancestors abandoned the cross appeal on this issue when Constitutional Appeal number 1 of 2006 was called. In the year 2008, I was a clerk then, a research clerk to Justice Katrebe. I witnessed the representative of the Uganda Law Society say those words. I abandoned the cross appeal on those grounds. I will name names. He was Senior Counsel Godfrey Rule. I accosted him at the exit and I said, why did you abandon that ground? Honorable Lord Mayor, Senior Counsel Rule told me, look at me, 79 years old. I have defended the appeal of government on almost 47 sections. I had no energy left in me to argue the cross appeal. When we began doing this case, Mr. Semakade, there were 2022, sorry. That's a year after the Kavazgiruka. A chilling effect that silences critical voices and perpetuates a culture of fear and repression. When 23 lawyers resolve that the matter is beyond them now, they must hand it over to the radical new bar to lead from the front, because it can no longer be resolved through private client briefs. The agency of advocate-client autonomy has been exhausted. You have a duty to the public and to the society to report the limits of your capacity. You have done that. And we have received it in the Marshal reconvene on the 3rd of February.
Which is supposed to fight for all of us, and